The courthouse stood at the center of a quiet Pennsylvania county, a place most families associated with routine hearings, traffic tickets, and the slow machinery of local justice. Few suspected that behind its orderly facade, a system designed to protect children was being turned into a pipeline for profit. In the late 1990s and early 2000s, juvenile crime in Luzerne County followed familiar patterns seen across much of the United States. Minor offenses dominated the docket: school fights, petty theft, truancy, disorderly conduct. Traditionally, such cases resulted in probation, counseling, or community service. Detention was meant to be a last resort. That changed quietly. Children began leaving courtrooms in handcuffs. Parents watched in shock as their sons and daughters were removed after hearings that lasted only minutes. There were no lengthy explanations, no meaningful defense. In many cases, no lawyer at all. The judge's rulings were swift, final, and unforgiving. Juveniles were sent to detention facilities for acts that once would have earned warnings or counseling referrals. Inside the courtroom, efficiency was praised. Outside, families began to notice a disturbing pattern. Children with no prior records were being locked away. School-based incidents were being criminalized. Probation violations for trivial missteps resulted in incarceration. The system no longer seemed focused on rehabilitation. It seemed focused on throughput. What most families did not know was that the detention centers receiving these children were privately owned. New facilities had appeared almost overnight, marketed as modern solutions for juvenile rehabilitation. They were expensive to build, even more expensive to maintain, and they needed beds filled. Behind closed doors, two judges, trusted public officials sworn to uphold the law, had secretly entered into financial arrangements with the very developers who owned these juvenile detention centers. In exchange for ensuring a steady stream of inmates, the judges received millions of dollars in payments disguised as consulting fees and investments. The courtroom had become a conveyor belt. Children as young as 8 were sentenced to months in confinement. Teenagers were removed from their homes and schools for offenses that posed no threat to public safety. Some were sent away for creating parody social media pages, others for schoolyard scuffles. Many had never even met a defense attorney before standing before the bench. The legal safeguards meant to protect minors were systematically ignored. Waivers of counsel were routinely accepted without proper explanation. Children were pressured to plead guilty without understanding the consequences. Parents were discouraged from asking questions. Hearings moved so fast that due process became a formality rather than a reality. Behind the scenes, the numbers told a different story than the court transcripts ever would. Juvenile incarceration rates in Luzerne County skyrocketed, dwarfing those of neighboring counties and national averages. Judges who once prided themselves on strict discipline were now delivering sentences that legal experts would later describe as extreme, unjustified, and unlawful. Every child sent away meant more money flowing into private accounts. The detention centers expanded. Staff were hired. Construction loans were paid off ahead of schedule. Meanwhile, families struggled to afford legal appeals, therapy, and the long-term consequences of incarceration on young lives. Inside the facilities, conditions were harsh. Children reported isolation, intimidation, and psychological trauma. Education was minimal. Counseling was inconsistent. The promised rehabilitation rarely materialized. Yet the court records showed success. Cases processed quickly, sentences delivered efficiently, statistics that suggested a system functioning smoothly. For years, no one outside the county fully understood what was happening. Complaints were dismissed. Appeals were denied. Oversight agencies trusted the integrity of the judiciary. The very people empowered to question the system were the ones benefiting from its operation. It was not until investigative journalists, whistleblowers and federal prosecutors began examining financial records that the machinery started to break down. Money trails emerged. Shell companies were uncovered. Payments once hidden behind legal jargon were revealed for what they were: bribes. By then, nearly 3,000 children had passed through the system. Their childhoods interrupted, their records permanently altered, their trust in justice shattered. And the judges who sent them away continued to sit behind the bench, delivering sentences in a courtroom built to protect the innocent, while quietly profiting from their suffering. The federal investigation did not begin with outrage. It began with spreadsheets. Bank records were examined quietly. Corporate filings were cross-checked. What first appeared as routine financial disclosures began to show anomalies: payments routed through intermediaries, consulting fees that made no sense for sitting judges, investment returns that far exceeded anything justified by market conditions. As prosecutors followed the paper trail, a hidden architecture emerged. One judge had helped shut down a county-run juvenile detention center, citing safety and maintenance concerns. Almost immediately afterward, a privately owned facility opened nearby. The timing was not coincidence. The closure eliminated public competition and guaranteed that juveniles would be sent to the private centers instead. Every ruling now carried a financial consequence. The more children sent to detention, the higher the occupancy rates. The higher the occupancy rates, the more lucrative the contracts became. The judge's financial interests were directly aligned with incarceration, not justice. Emails and contracts revealed language carefully designed to obscure the truth. Payments were framed as legitimate business partnerships. Shell companies were used to disguise ownership stakes. Money moved slowly, deliberately, through layers of legality. On paper, nothing looked illegal. In reality, the system was engineered to convert sentencing power into cash. When federal agents finally interviewed families, a different record emerged, one that never appeared in official court documents. Children described hearings that lasted less than 2 minutes. Parents described being silenced when they tried to speak. Defense attorneys recalled being excluded entirely or learning about cases only after sentences had already been imposed. Some children did not understand they were pleading guilty. Others did not know they had a right to an attorney. Many believed the judge's decision was mandatory, not discretionary. None were told that the judge, profiting from their incarceration, had a personal financial stake in the outcome. The psychological damage was severe. Children returned home withdrawn, anxious, aggressive, or depressed. School performance collapsed. Relationships with parents fractured. Some never recovered academically or emotionally. A juvenile record followed them into adulthood, limiting job prospects and reinforcing cycles of instability. Inside the detention centers, staff turnover was high. Oversight was minimal. Rehabilitation programs existed largely on paper. The facilities were designed to hold, not to heal. Yet the judges continued to justify their actions publicly as tough but fair. Behind closed doors, federal prosecutors prepared their case. When indictments were finally unsealed, the reaction was disbelief. A sitting judge was charged with racketeering, fraud, and conspiracy. Another judge faced similar accusations. The allegations were unprecedented: that a court of law had been transformed into a profit-generating enterprise fueled by the incarceration of children. The legal system, designed to be a shield, had become a weapon. Court proceedings that followed exposed the scale of the betrayal. Evidence showed millions of dollars exchanged for judicial decisions. The moral authority of the bench collapsed under the weight of financial greed. One judge eventually pleaded guilty, the other went to trial. Sentencing hearings were unlike anything the county had seen. Former juvenile defendants, now adults, described years lost to confinement. Parents described watching their children escorted away in chains for mistakes that should never have led to prison. Judges who once wielded unchecked authority now stood as defendants themselves. Convictions were secured. Prison sentences were handed down. The architects of the scheme were removed from power, stripped of their robes, and publicly condemned. But accountability came too late for thousands of families. Appeals courts later ruled that the juveniles' constitutional rights had been systematically violated. Nearly 4,000 convictions were vacated. Records were expunged. Official apologies were issued. No apology could restore lost childhoods. The scandal forced national scrutiny of private detention, judicial oversight, and the vulnerability of children within the legal system. Laws were revised. Ethics rules tightened. But the underlying truth remained unsettling. The abuse did not require secrecy alone. It required trust. Trust that judges would act in good faith. Trust that institutions would self-correct. Trust that children would be protected simply because they were children. That trust was exploited, methodically, legally, and for profit. The final phase of the scandal unfolded not in courtrooms, but in the aftermath, where consequences were measured not in sentences, but in damage. Once the convictions were overturned, officials faced an unprecedented task: repairing a system that had failed children at every level. Review boards were assembled to re-examine cases one by one. Thousands of juvenile records were erased, but the impact of incarceration could not be undone by paperwork. Years lost to confinement did not return. Trauma did not dissolve with expungement. Psychologists documented elevated rates of anxiety disorders, depression, substance abuse, and post-traumatic stress among those affected. Many former detainees had dropped out of school after release. Others cycled through the adult criminal justice system, their early exposure to incarceration shaping behavior and self-identity long after childhood ended. Civil lawsuits followed. Families sued the judges, the private detention operators, the county, and the state. Settlements reached tens of millions of dollars, paid by taxpayers, not by the individuals who designed the scheme. Insurance carriers covered part of the damage. Public funds covered the rest. The financial burden of corruption shifted downward, away from perpetrators and onto the community. The private detention facilities closed quietly. Buildings were sold or repurposed. No memorial marked what had happened inside them. No public accounting detailed how many lives had been altered behind their walls. National outrage spiked briefly, then faded. Judicial oversight commissions promised reform. Ethics disclosure requirements were strengthened. Judges were required to recuse themselves from cases involving financial conflicts. Some states reviewed their relationships with private detention providers. Yet the core vulnerability remained. The scandal exposed how easily unchecked authority could be monetized when transparency failed. It demonstrated that judicial corruption did not require violence or intimidation, only complexity, legal language, and time. By the time wrongdoing surfaced, thousands of decisions had already been rendered, each one cloaked in legitimacy. Most disturbing was how ordinary the system had appeared while it operated. Courtrooms functioned normally. Dockets moved efficiently. Paperwork was filed correctly. The machinery of justice never stalled. There were no alarms built into the process to detect moral collapse. The abuse hid in plain sight, camouflaged as productivity. The children at the center of the scandal were not selected because they were dangerous. They were selected because they were powerless. Many came from low-income families. Some had learning disabilities. Others had no prior criminal history at all. Minor infractions, schoolyard fights, truancy, petty theft were escalated into incarceration. The threshold for detention dropped until confinement became routine. In effect, childhood itself was criminalized. Years later, investigative journalists reconstructed timelines and financial flows, revealing how early warnings had been ignored. Whistleblowers had raised concerns. Defense attorneys had complained. Parents had protested. Each signal was dismissed as anecdotal, emotional, or disruptive. The system protected itself until it could no longer do so. The judges at the center of the scandal became symbols, but they were not anomalies. They were products of a structure that concentrated power, reduced accountability, and allowed profit to intersect with punishment. No single reform could guarantee prevention. The story left behind a question that still unsettles legal scholars and child advocates alike. How many similar abuses never reach daylight because they operate just within the bounds of legality? The scandal did not prove that the justice system was broken everywhere. It proved something more troubling, that when oversight weakens, justice can be sold without breaking the law outright. And when that happens, children pay first. The case ended on paper with convictions, vacated sentences, and policy changes. But the true conclusion remained unresolved, carried forward by those who grew up too fast inside detention walls built for profit. It stands as a warning, preserved in court records and lives altered beyond repair. Not of what one judge did, but of what a system allowed.